It's time, so we shall begin. We've got 4 applications up for decision. First one being 2846, number 40 on Meadow Lane.
I move we accept this decision as proposed.
I'll second.
All in favor?
Aye.
Anybody want copies?
I don't have
Hold on just a second, I brought a couple of extras. There you go.
Thank you.
Pardon?
May I have a copy as well?
Okay, you are?
Rob Kelly from Cal Fritz. I have to
Oh,
email
okay,
it to
sure.
the Hog office. Thank you.
Okay, I don't have any more copies with me.
I got one here if you want.
Yeah.
Thank you.
Okay.
Thanks very much.
That's not the official one for the file that you're giving her.
No, that's the one that you sent me by computer.
Oh, okay. Okay. Just want to make sure we
No,
leave it.
that's not the one that's in the file.
Okay.
Thank
I
you.
assume there's one in the file. Yeah, it's right here. On the application of case number 2861, Ophir Kadar, 111 Hetty Creek Lane.
I move we accept this decision as proposed.
Okay, let's just add to that, it would be a motion to accept the wetland special permit and negative declaration as prepared by our environmental consultant.
So moved.
Second.
All in favor?
Aye.
The application of case number 2862, William and Sharon Jacob, 52 Bishop's Lane.
I move we accept this decision as proposed.
I'll second.
All in favor?
Aye.
Anybody need a copy? Okay, just hold on a second.
Yep. You have a copy for her?
Yeah, just hold on a second, let me find it.
There's one here.
Let's see, this one is Jacob, right? Is that the one you're looking for?
I'm sorry.
Oh, right, we just gave out 3 copies.
Do you have an extra one?
No.
I just gave out the one I had too.
2862.
There's one to read there if you want.
Oh, sorry.
2846,
It's fairly lengthy.
2846.
Fine. Thanks.
Or was it?
Number 4.
Oh, yeah. The application, case number 2868, Anthony Albanese, 64 Almond Street.
I move we accept this decision as proposed.
I'll second.
All in favor?
Aye.
Anybody need that one? Albanese. Pardon?
Is there another one? I'm here.
Oh, okay, who was he?
Albany.
Hold on. I'm pretty sure I have another one here. Albanese, yes.
Great, thank you.
We have 2 requests for adjournment. Cases number 2848, 120 on Meadow Lane, and 2859, 140 on Meadow Lane.
No, it's 47 or 48.
I'm sorry, 2847 and 2848, 140 and 120 on Meadow Lane.
I move we adjourn those cases.
I'll second.
All in favor? Aye. That brings us down to the pending cases, the first one being 2859, 70 Meadowmere Place.
Mr. Chairman?
Yeah.
Yes, I just wanted to indicate to the board that I'm going to recuse myself from this application.
Okay.
It was, the reason is because our sister company, Nelson and Pope, did some engineering work for the applicant, completely unrelated to anything that comes before this board, but just in order to remove any appearance of conflict, I think it would be best to do that. The board has a backup consultant when this type of situation occurs. And so that consultant has had the opportunity to review all the files, and I believe a letter was provided to the board just in anticipation of tonight's hearing. So I'm going to recuse myself, and the other consultant would be able to follow up as needed based on the board's direction.
May I have a copy of it? Good evening, Melissa Dedovich, Peconic Environmental Associates. I'm here on behalf of Meadowmere Place LLC. You may remember this property. It has a history. We had gotten, originally it was a vacant lot. Back in 2011, we received a wetland special permit for a portion of the residential work that was going to be within the jurisdiction of the ZBA, as well as for a slope replanting plan. We then came back in 2012 for a wetlands restoration project of the actual wetlands area and the buffer. Now we are here in front of you with, and originally it was a 4 by 60 foot catwalk. It has been reduced now to a 4 by 41 foot catwalk with a step up, a 4 by 4 foot, 4 foot by 4 foot wide steps to the water. If you look on your plan that was submitted, it goes, this is the wetlands area, so it provides access from the buffer area across the wetlands to Halsey Neck Pond. You also may notice on this that this property already has an established 125-foot native buffer area. That's what's here. This is the slope here. This is the wildflower meadows that were previously approved by this board. You should also have copies of the actual specifications. I know you have a long agenda, so I'm just going to jump down to, just so the board is aware, we have received trustees' permits. You only want, okay. All these were hot off the press, so I apologize. We literally got them at 4 o'clock today for the proposed project as shown. And the DEC wetlands, both freshwater and tidal wetlands project, permit for this project. Again, these were just issued on March 14th, again for the reduced project. And I am pretty much here to answer any questions you may have. Mr. Voorhees was kind enough to call me and inform me of the fact that he was going to have to recuse himself, but it's my understanding that the consultant really had no concerns with regard to what we're currently proposing, as it's actually providing an access that previously was supposed to be a walkway down or just a pathway down to the water. We are now putting a catwalk over the wetlands to provide access to Halsey Neck.
While we're at it, we have a letter from the neighbors immediately to the south, Callahan, in opposition to this project. And earlier we had a letter, not last meeting, but this was adjourned last meeting. The first time we heard this, there was a letter from another neighbor in opposition to this project.
Correct, and if you read what the opposition is about, it's about utilizing Halsey Neck Pond.
Yes.
Which my understanding from talking to Ed Warner Jr., who's the president of trustees, that everybody in the township of Southampton and the village of Southampton has access to the underwater lands in the township, hence we are allowed access to the water. And if somebody wants to kayak in Halsey Neck Pond, there's nothing preventing them from doing so.
You can actually go out in that pond with a boat?
You can kayak on it. You're not allowed to have anything with a motor on it. You can kayak on it.
And we also have a letter from Michael Walsh. He's not here. Is somebody here from Michael Walsh?
Yes, here.
You represent the neighbors now, right?
I do.
Did you want to come up and say anything?
I do.
Good evening, Mr. Chairman, members of the board. My name is Anton Borovina. I'm actually here to fill in, but with Michael Walsh, who is unavailable today. But I'm involved and have been involved with respect to this application, and in opposition to it, I represent Mr. and Mrs. Sklinski, Mr. and Mrs. Callahan, Mr. and Mrs. Fensterstock, and Mr. Picard, who are neighbors and have properties within the zone of interest affected by this application. This is the first time on that we would like to study it further. We note that it is deficient in several respects, including the fact that insufficient notice was given as prescribed by the village code. Insufficient notice was published in the 2 local papers as prescribed by the code. There was a failure to comply with SECRA, and that there was no lead agency designation as required by the code and by the statute. This is a type 1 action by virtue of the fact that it is a wetlands permit application. We also are looking into, under the code, only those structures, subordinate use buildings and structures customarily incidental to what the lot is being used for, which in this case is a home. And it is our view, based upon the fact that this pond does not have any catwalk, I would say that, by the way, the use of a kayak is not the equivalent of a catwalk. Catwalks are, of course, structures. Kayaks are not. And there are other issues associated with the application that we need to look at. And for this reason, I request that the public hearing be kept open and that we have our opportunity down the road to submit further objections in addition to the ones that have been filed with the village earlier today.
Do you have any rebuttal?
Yes, please. Thank you. As you may recall, this was originally published to be heard in February. We adjourned in February, and then we adjourned in March. There's been plenty, if not more than enough, notice given to the neighbors about what the plan was. In fact, in the meantime, we were working with the DEC and the trustees, and as I said before, the project was cut down by 19 feet. We were requested by both the trustees and the DEC to bring it down to the shoreline to provide access for a kayak. Now, the other thing I hate to bring up is the fact that the people in question who are raising this both have catwalks. Can you raise that? The Klinskys and the Callanans both have catwalks. This was brought to my attention, actually, by the president of the town trustees, Ed Warner, who came to my office to talk about this project and said, "Do you know there are 2 illegal structures on that pond?" I said, "No, I was not aware of that." It is my understanding that right now there's a summons on the desk of John Foster to both the Klinskys and the Callanans for not having the proper permits to install similar catwalks on their property. I have aerial photographs from 1984 that show clearly there are no any kind of catwalks, docks, or any kind of structure like that. In the pictures you have that are individual shots of each one of those properties, you can clearly see that there are catwalks. In fact, the Klinsky catwalk is extremely long, and it's my understanding that now they're going to have to rectify that in village court, again, per my discussion with both Ed Warner Jr. and with John Foster at the building department. He was particularly surprised about the Callanan one, since they had agreed to a buffer as part of an addition to their house, and they were notified that any kind of structures in that wetland buffer would require permits from not just this board, from the DEC, as well as the town trustees. So again, I would ask this board that, based on the merits of our own project and the fact that we already have a 125-foot buffer, and the fact that we've gotten the approvals from the town trustees as well as the DEC, who, if you look at your village law, a case could be made that actually this is outside of your purview, just because on section 116.19.3, I'll skip to the chase, D, the approving authority with respect to all applications shall be the zoning board of appeals, except that the town of trustees have the approving, shall be the approving authority with respect to any wetlands or regulated area already under their jurisdiction upon the effective date of this chapter. So in such latter case, the zoning board shall be deemed an involved agency pursuant to SECRA for the regulated activities not under the town trustee jurisdiction. Really, the only reason we're here is because in the original approved planting plan for the restoration, you can see a walkway was approved to go down to the water. So really all we're asking for is to shift the walkway a little bit, the pathway a little bit, to provide access to the catwalk, to provide access to the water. Environmentally, we're offering to put a walkway to protect the wetlands with a 60% flow through to allow the vegetation to grow up, as opposed to having a 4-foot wide pathway to just walk down to the water. I'll leave this open for you too. So I respectfully ask that the board look at this on its merits and close this hearing tonight for decision.
Do you have any questions from the board? Rick, any questions?
No questions. This is a very minor application.
Anybody out in the public would like to be heard to this application? Right here.
Mary Callanan, known as Maureen Callanan. When we purchased that property, which was well after the photograph is 1984. We bought it at, I believe, in 1988. We built in 1990. When we purchased the property, there was a walkway to the pond. I don't know where it came from between the time we purchased it and that photograph. A few years ago, it had overgrown. It was falling apart. We rebuilt the structure. It's just a pathway. It's just a wooden path which measures 30 feet by 4 feet. So I don't know what the problem is.
You don't know how it got there, did you say?
No, I'm saying this is a photograph from 1984. This was 4 years before we bought the property. And when we bought the property, there was a pathway there to the pond.
You said you rebuilt it?
It was coming apart, and we just put new wood, at the bottom. I mean, it was a repair.
So we're saying it was not there in 1984, it is there in 2015.
It's not, this is what Ed Warner Jr. from the trustees told me, no permits for any have ever been applied for in Halsey Neck Pond for any structure. That's my understanding. So it may have been there, but it was there illegally.
Well,
The contention is it was there when they bought the property.
Yes, it
Again,
was.
to our
Yeah.
picture on 84, it doesn't appear.
We didn't own the property in
It
1984.
happened between 84 and 88.
Thank you.
It would be in their survey.
You don't they get that survey when you buy it? You get a survey.
Right.
Yeah, there
So
should be a
how's it
survey
go on the-
That would show it or not show it.
Yeah.
I mean, before 88, it was just an empty piece of property, right? There was no home there until after you bought it.
Well, do you think that the proposed catwalk is more of a danger to become a recreational platform than yours is?
It's closed at the pond end. There is no direct access to the pond from the end of that walkway. There's a permanent closure.
Closure.
And in the 25 years that we've been living there, no one has used the pond for recreational purposes.
Probably the neighbor
I mean,
put it in when this was all just open field.
The fact that they haven't doesn't mean that they can't, though. It can be used. It just hasn't been. Is there anyone else out in the public who has heard of this application? You want to close it, Rick, the decision?
Okay, they have a DEC permit. They have a town trustees permit. At most, our jurisdiction would relate to the catwalk that's landward of the high water line. So we're not dealing with the part of the project that goes into Halsey Neck Pond. That's the town trustees and the DEC. So all we're looking at is the proposed catwalk that is landward. All we can look at is the proposed catwalk that's landward of Halsey Neck Pond. Why don't you close it, subject to an opportunity for the attorney for the objecting neighbors to submit written comments prior to our work session.
The work session.
That's sort of
is-
like a compromise.
Can I just clarify something for you really quickly? Just to remind you that actually DEC has jurisdiction, both freshwater and tidal on this. So they actually have jurisdiction of 100 feet for freshwater and 300 feet. So the whole project is within the DEC's jurisdiction, and they have issued the permit for that.
I wasn't suggesting that they don't
No,
have
I just wanted
jurisdiction
to-
over the whole thing.
The way it sounded, just so.
I was talking about our limited jurisdiction.
Agreed.
That would be a compromise. It's up to you. I mean,
So that sounds all right to me.
So I move we close for decision, but allow for input from the opposing neighbor's attorney
Prior to the work session.
prior to the work session.
I'll second.
All in favor?
Aye.
On the application of case number 2864, John Nielsen, 50 James Street.
Good evening, Nicholas Vero, architect, 120 Mill Road, West Hampton Beach. I believe at the last hearing, Mr. Petras requested that we submit existing conditions survey, some additional information on site plan as it relates to lot coverage, photographs of the existing condition of the site, and there was a request to relocate the swimming pool 5 feet south of the north property line. And I believe we've met all those requests.
What's that say?
So that's 21 feet.
That's 21 feet to the,
Right, okay, so they didn't come anywhere
that's
here.
15 feet.
They didn't move the patio.
No, they were supposed to shift the patio to the other side, to the south.
We're actually moving the patio in between the house and the pool.
The patio is still there.
Patio's still there, the same.
On the site plan or the survey, I don't know, with Nathan, did he move the pool?
21 feet from
Pool.
15.
Move the pool 6.5 feet, I guess, but the coping of the patio is not moved at all.
There is a site plan that I submitted, which also has some my own personal site plan.
See, this is still right 3 feet.
Oh, he did not move the patio. I apologize for that. And that's the newest one? That's the latest one that I gave you?
This is April
Okay,
14th.
my apologies. I do have a site plan that I submitted on my own drawings that do show that, but I apologize for that not being on the survey. I thought he did that. My apologies. So we're gonna relocate the patio completely between the house and the pool and get it completely away from the north property line. So my apologies for that. I thought Nathan did that on that survey.
In other words, that patio to the north will be
Gone,
gone.
correct. Just
So there'll be
strictly
patio between the house.
house, yeah. Because I think your suggestion was put it on the south side, which we didn't really want to do. I'd rather have it between the house and the
Near the
pool.
street there, yeah.
But I should have a site plan in there, my own site plan that does show that, so the intent was there, but I will revise that on the survey and get that back to you ASAP. Sorry, my fault.
You want to close it? Oh, see, what is
I
submitted?
don't see the site plan.
Here's the old one.
Yeah, that's the old one.
we do have
No difference as far as this
we do
goes.
have a revised survey that was with our work session packet that shows the swimming pool 20 feet from the north line as we had asked for, and it doesn't show any patio.
The patio was gone on that survey?
I don't see any
May
patio
I?
on this
I'm sorry.
survey.
I thought he did do.
I don't know, but
That's the.
What's this? It's, we have it right here. It mimics what is there. He shows, depicts the patio by the house, but he didn't remove the old one.
one that I just submitted, correctly?
okay, I don't know what this is. Is that something?
Yeah, that's, he's showing that patio to be removed. May I look at the one that you're?
Yeah.
Must have a different one than I have.
float, throw it. Existing conditions.
That's all I got. That's all I have in my packet.
My apologies, I don't know why.
All right, here's another one here.
But that's not existing because it does show your new patio by the house. It just doesn't remove the
No,
old.
but that's the existing condition plan. That's the existing house. That's the
Right.
way the,
This one.
so,
Here's one that came in also April 14th.
right, that's my site
Yeah,
plan.
there's-
But we did do,
Got confusing.
okay, but we do
Okay.
have surveys, and I did submit the
Yeah,
surveys.
but the survey shows it still there. Your
And do
site
you have
plan shows
8?
it not there.
Do you have 8 of them? No. Okay. Yeah.
No,
That's the one that we want to submit. This is
I don't know what this is here.
That's showing that patio's to be removed.
It doesn't say anything about it.
It doesn't say it. It shows it on this plan.
Proposed two-story house, proposed pool, 20 feet. He showed the pool relocated, and I put the patio on my side. This is correct. He was looking at the existing condition plan. And that's the old one.
Existing.
That's the old one.
Yeah,
That was
right.
the originally submitted one.
Yeah, the new one is not showing any proposed patio.
Right, okay, but I'm showing.
I
it
don't
on
know
my
what
side
those
plan.
dotted lines are.
We don't have it.
Okay.
Maybe,
We showed, on the survey that we submitted, Nathan showed just the pool and not the patio. He showed the pool 20 feet off of the north property line. He didn't show the proposed patio. I showed it on my site plan, but I'll get it all on the one survey.
Okay.
Okay?
all right. So then,
As
your
requested.
survey, we're gonna agree with this site plan.
We're gonna agree with that site plan. So if you look at that site plan, it shows the
have that
pool.
site plan.
No, there was one in the file.
There should have been a bunch of
Came
those
in
in the
the same
file.
day as
Yeah,
the-
they all
as
came in the same day.
survey.
With multiple copies?
Yeah, there was only one copy in there?
Pardon?
One copy,
That's all?
one copy of your site plan.
There should have been a bunch of them, so my apologies. Okay,
Maybe it's not your fault.
And the other thing that we had asked for,
mm-hmm.
I don't know if you submitted it or not, it wasn't in our packet at the work session. We asked for elevation plans from the Post Lane view as to the existing house and the proposed house, so we could have a comparative.
I did photographs of the existing house. So, what I submitted, as per your request, I actually gave revised surveys, original surveys, existing conditions, which I have my transmittal right here, revised site plan, which was mine, which shows all of the criteria, the pool, the patio, and I gave 2 sets of the photographs of the existing house to compare to the new drawings. Unless you want a drawing from me of the existing house, I mean, I can duplicate that.
I don't have anything, so I don't know what you filed.
It's exactly what I told you that I filed. That's my transmittal, which I gave to the building department.
Or did you transmit multiple copies?
Yes?
Are they in the file?
There's one copy in the file.
And the pictures, you have one.
Problem here is that the site plan and the survey do not agree.
Right.
That's where the problem.
That's what you're telling me, right? Because it's not showing the patio according to what the
Right.
survey that I showed.
So what we need is a new survey that shows the absence of the north patio.
The elevations either.
You don't have the elevations either, you say, Rick?
But I don't care about that.
I did give multiple copies. It was the day of your work session that they were brought in. So I'll resubmit the surveys to reflect everything that's on my site plan.
Okay.
I'll give you multiple copies of the photographs unless you want a drawer and elevation of the house the way it is. I mean, I can do that.
The way it was, it's been demolished, right?
Right, exactly, the way it was, right.
Oh, it's not there now?
No, it's not there now.
It's gone.
Do we have the proposed elevation plans?
Yes.
I'm not asking
I'm
you,
sorry,
I'm
Bob,
asking
sorry.
Kevin.
No, we have the pictures of what was there, right?
You have the pictures of what's there,
What was there?
right?
What was there?
Right.
Who cares?
Now, in this packet,
You
which
have-
is the site plan, which is correct,
Has a full plan.
And elevations of the house.
all elevations,
Mm-hmm.
chimney cap details, flat shingle details, basement plan,
I had elevations.
They have elevations in there.
the elevations,
You weren't, you were reading, but you weren't
did I pass-
looking.
did I pass them up?
The pictures were, in other words,
Look at the pictures.
thing right here.
okay. Let's show this to Rick. This was in the file, but not in the packet.
Okay, this is the site, your site plan that you're talking about?
Correct.
Okay. That shows what we wanted.
Mm-hmm.
And there are elevations here, which we asked for,
Correct.
but apparently we didn't get multiple copies.
No.
I forget
Well,
why we
file
needed
copy.
the elevations.
Hmm?
I forget why we needed the elevations.
I think you wanted to compare the south elevation to what was there, so that's why I gave you the elevations, and I did that with photographs of what the existing conditions were.
But they don't require a variance of any kind.
No, we don't require, we're not asking for a pyramid variance. We withdrew that at the last hearing. We complied to pyramid.
So arguably, we don't need the
It
elevation.
needs a front yard variance from Post Lane, so
Correct.
Oh, okay.
Right.
we asked for the elevation plans just so we can see what it's gonna look like from Post Lane.
So,
Since it needs a variance from, it doesn't need a pyramid law variance or a height variance, but
You just want to see it.
I think you wanted to see what it looked like.
I forgot now.
So all we need now is revised survey, correct? That matches the site plan. That's all we need, right?
and multiple copies of the
Unless
elevations.
you want multiple copies of the elevations.
Multiple copies of the elevation, everybody here.
Two easy things to do.
Multiple copies for the survey.
What I said, multiple copies of the survey. I don't know why you don't have multiple copies of the survey.
Yeah,
Well,
but if we
you
want
do,
to
but they
compare,
weren't.
That's the only thing we compared to. You have photographs in the files, I didn't get photographs either.
Why would
Yeah, I
we
got
compare?
photographs in the file of what was there.
Right. so
Sometimes when you
Work session
file
was done.
something on the day of the work session, there's a lag. The village office doesn't
Sorry.
have time to put it all
Came in the
together.
14th, which
Yes,
was
it
the
did.
day of the
Yep.
work session.
Right there, 14th, absolutely.
So maybe you want to file them sooner.
Okay. Well, I'll have Nathan do the survey right away, make sure that patio gets back on there, and I'll bring it right back in, so, way before your work session.
We could close it for decision, subject to those submissions.
That's fine.
And that's all I'm asking for. And you will have those.
I move we close this application for decision, subject to submission of elevation plans and site plans / survey.
I'll second.
All in favor?
Aye.
Okay, thank you. Sorry for the confusion.
Okay. Yeah, that's right, the day
I
of.
got it in, just, when they already had everything all made up, you know?
Got that part too, man. Linden Lane, there we go. Complain, raise,
I should have a secretary.
a raise.
Well, that's true, that's true. That's why you shoved all this stuff over to me. On the application of case number 2865, CV&B LLC, 63 Linden Lane.
Chick, you want me to go ahead and start?
Sure.
Good evening, Rob Herman, Event Consultants, 1319 North Sea Road, Southampton, on behalf of the applicant. This is a continuation of a hearing that we started last month. It's a simple application for a 4x28 fixed timber catwalk that will provide dock access to Lake Agawam at the end of Linden Lane. Where we left off at the last hearing, Mr. Voorhees had raised a couple of issues that he had asked us to address, and the board asked us to address. And in response to that, I submitted a cover letter to the board dated April 16th, 2015. And one of the issues related to a question of trying to provide some additional supplemental plantings in the area of the proposed dock. And we have updated our plan that is now last dated April 16th to show some additional plantings of sweet pepper bush and inkberry in the area of the fixed dock, where the plantings that had been previously established pursuant to prior relief granted by this board had not succeeded. Mr. Voorhees and I met at the property to evaluate what plantings should be planted there, and we came up with these couple of species based on the fact that they were actually the ones that were doing quite well throughout the rest of the established buffer zone. And so sheet 3 of 3 of our plan now reflects that information. The other issue was just a request for a simple construction methodology, which I contained in narrative form in that April 16th letter. This is a very, very minor construction project in terms of this, so we don't have much to offer in the way of information, but we did provide the simple information in terms of what equipment would be brought to the site, how it would get there, the fact that we basically have a dock builder's single truck that will be parked in the driveway at all times during construction, and you're looking at a project that will probably take about 1 business week to complete. So I did include that information along with a few other details in that letter. So we're hoping that would satisfy Mr. Voorhees' request from last month, and otherwise, if the board has anything else, we're happy to respond to it now.
So they'll be able to keep the equipment on the property. You know, it gets very tight down at the end.
Yes,
of that street.
it does.
Extremely tight.
It does. Basically, you would have a single truck. The most equipment they're bringing down is a jet pump to install the posts. So there would basically be one truck that would be parked in the driveway on the applicant's property down there at the end, and then the materials can just be brought over by hand to the site, which is, what, maybe 50 yards away. There's really no heavy equipment that's involved here. There's no heavy machinery. It's a lightweight structure. It's 4x4 posts, prefab, fiberglass reinforced decking, and just the rest of the framing materials, basically simple lumbers, stringers, and so forth.
Any questions from the board? Rick?
No questions?
Dick?
Yeah, I can just confirm that Rob's description is accurate. We did meet at the site. We also confirmed the wetland boundary for the purpose of the permit plan. Went over the species. This was the area that had previously been approved with a fairly extensive restoration plan, but there was an area under an previously existing large red maple tree where the plantings didn't take. And also the proposed catwalk was not reflected on the original plans. So there's a supplement to those. We're basically taking out a piece to show the proposed catwalk, show the plantings, and that'll work in conjunction with the prior permit plan, which is all installed and doing well except for this minor area. So I'm satisfied with the content of the submission. I just have one very simple format request. And if the board would like, and there's no other comments, we can certainly have this ready for the next meeting so the hearing can be closed. My simple request is to just put the construction narrative on a separate sheet with a separate date.
Sure. So
that we can reference it in the permit conditions, and it'll just be a little simpler and cleaner than having it in this letter.
Yep, not a problem.
And that's all I have.
Is there anyone out in the public who'd like to hear this application? Close this for decision?
Yep.
I move we close this application for decision.
I'll second.
All in favor?
Aye.
Thank you for hearing us.
Remember I told you a house sold for $5 million down there? At least 20. It's crazy. As I remember. Crazy. Paper 3 weeks ago. Is he still around?
The application of case number 2866, John Sideris, 237 Meeting House Lane.
Good evening, Mr. Chairman, members of the Board Council. For the applicant, John Sideris, I'm Lisa Combrink from the Toomey Latham Law Firm, 51 Hill Street, Southampton. This matter was heard at your hearing last month, and you requested that we submit a revised survey showing the proposed garage moved east from the side yard from 5 feet to 10 feet. So we had that modification made on the revised survey, and that was submitted prior to your last work session.
There it is.
And I think that was the only item that we had outstanding at that time.
Does that mean that the garage meets the setbacks from the east and from the north?
Yes, it does.
That's that house across from the hospital.
What is directly north of that property line?
Directly north, to the northwest, there is a house on Lewis Street in this notch area where the garage would be, but in that particular area there's vegetation, there's a large tree. I believe I submitted photographs at the last hearing showing that. The house that is adjacent is closer to Lewis Street than to the back of the property.
So in that corner, then, there's no activity, there's no home?
There's not a pool back
No
there,
pools?
nothing. It's just, as I said, a very large tree. I think it's an evergreen, and then there's some kind of scrawny-looking hedges.
Yes, I think the neighbor had voiced a few concerns.
She did, yeah. I think she wanted it moved a little further over, so.
But it does meet the setbacks then.
Yeah.
The neighbor's there.
Do we have any questions from the board?
No.
Rick?
No questions. They submitted the revision that we asked for.
Anybody out in the public wish to be heard of this application?
Open for decision?
Yeah.
Move we close this for decision.
Thank you very much.
Second?
All in favor?
Aye.
Bring on this side. Fine.
Yeah, yeah.
Not the garage, too. On the application of case number 2867, 117 Wickapog Road Associates, 117 Wickapog Road.
Nope, they didn't move it.
We got two.
Anybody missing one?
One of the five. Is that the latest one?
Yeah, this was the stuff that came in.
Also,
Yeah.
14.
Sure, we've got all the plans. I don't want to get okay.
2.5 feet.
Good evening, members of the board, council. My name is Monica Navi. I'm an attorney with Burke & Sullivan, 41 Meeting House Lane. I am representing the applicant 117 Wickapog Road Associates. And this is a continuation of the hearing from last month where we left off. And to refresh your recollection, the premises are located within the boundaries of the village of Southampton, subject to the restrictions of the R80 zoning district. The premises are 16,571 square feet in size, where 80,000 square feet are required. We listened to your recommendations for our revisions from last month. We made modifications to the survey that we did submit. And based on what you had recommended, you recommended that instead of the 55-foot variance in the front that we requested, you recommended that we ask for 60. So based on that recommendation, we created a site plan and a survey to reflect the 60-foot front yard setback. And for the side yard, as a compromise, you had also mentioned 7.5 feet would work instead of the 5 feet that we originally asked for. And that will prevent us from having to move the pool over. That will increase safety visibility for driving the cars into the garage. We'll put the proper screening up to alleviate any concerns. And again, we made the garage smaller, if you remember, than we are entitled to. So at this point, we request that you judge our application on its merits and close it for a decision.
I don't quite see why you move it over another 2.5 feet, it impacts on the pool.
I don't remember suggesting the compromise of 7.5 feet.
No, I think
at
we
all.
talked about 10.
10 is,
I do remember Mr. Ercolino and I mentioning 7.5 at some
that's
point,
not-
but I
that's your
respectfully.
compromise, that's your-
You could also make the garage a 17-foot wide garage, which is not a 2-car garage, it's a really large 1.5 car. You could make it 17, or you could make that 15 feet and still have an oversized, because a single garage is 12, so you could go to 15, still have 3 feet on it, so you can pick it up without, you
What's the
know.
garage now? How wide is the garage?
If you look at the site,
17?
at the, yes, with me is Fred Ercolino, the architect, as well. If you look at the survey that we submitted for the 60 feet front yard setback, and then we put the 7.5. If we were to have it at the 10, we would have to basically move the pool over, would require us to come back here and request another variance. And the way it is now, at 7.5, if you look at it, it's a straight shot in. If you're, for maneuvering, for visibility, for safety, coming up the gravel driveway, you go directly into the garage. If you would move it over 2.5 feet, then it would require having to drive into the left part of the garage, and then we would have to move the pool. So at this point, we feel that we did listen to your recommendations, we did modify it, and we feel 7.5 is a fair compromise.
Well, see, the issue here is you're dealing with an empty lot. You're dealing with a blank piece of property. In other words, if the garage was already there and you wanted to add on to it, non-conforming, that's one thing, but the garage is not there. There's nothing there.
That's
So
correct statement,
I really don't see why
yes.
you can't make the garage conform.
Well, we actually did make the garage smaller than we were entitled to, so we do feel like we're,
I mean, conform to the setbacks.
Mr. Ercolino, the architect, do you want to speak to that? Do you want to come up?
Sure.
Yes. Questions?
The question is, why can't the garage conform to the setback, to the easterly property line? You had 5, now you got 7.5, and we were talking about 10.
You know, if you move it over 10, the garage just can't be 17, it'd have to be 14 and a
Okay, so
half.
tell them that.
Yeah, but we have to speak to the owner about that.
Right, we'd have to talk to our client, obviously, about that.
We understand, and I believe we proposed a 10-foot side yard then with a 14.5 wide garage, but we need to speak to the owner about that, who's not here.
And again, we respectfully request that the 7.5 is a fair compromise from the 5 that we were requesting. At 10, again, we would have to potentially move the pool over. If you look on the survey, if
could
you
also
move it
make
over, the garage,
deeper If you need the storage in their space.
Exactly. If we make the garage 14.5 feet wide with a 10-foot side yard, the garage can be 32 feet long now to make up the square
Yeah, so you
footage
have
for the storage.
Have some storage toward the back of the garage.
Behind the car, yeah,
Yeah, behind the
as
car.
opposed to a good amount on the side.
Right.
But the attorneys will have to speak to Wickerpog Associates about that, I guess.
yeah, oh, obviously, yes.
Well, maybe it should be pretty clear with them how we feel.
I definitely will.
Is there anyone out in the public who'd like to hear of this application? Please come up.
Thank you all for giving me this format. Robert Schwartz, 127 Wickerpog, the adjoining property. I was here at the last application, and I guess my understanding for the basis of any variance is to address hardship and compelling need. My neighbor has a vacant lot. I'm not sure there's any structure of any kind has been implemented, so I don't see the viable reason why my family should be subject to a compromise to make the garage narrower, to simply comply. I bless the idea of moving the house forward. I accept that. I have no issue with that. But our property is equally as small, and I don't see why we need to be compromised so that they could be closer to us. We complied when we built our lot, so I'm just asking for the same set of ground rules for everyone else to apply.
Oh, I think you heard just what we said.
I'm just expressing our views.
No, that's good. No, that's
And
fine.
you also need to know that
We understand that completely.
the positioning of the garage is dead center of our family's living room and of our family room, which are the nicest views in the home. So I'm not excited at the concept of looking at a garage at any depth perception. The closer, just, I don't see the need to make the garage narrower, to do whatever it takes to comply. Just seems to me to be with our neighbors, and I look for an amicable relationship for a long time, but it just seems to me that that's what they should do. They
So
should
how do you
conform
feel
to the
about it
rules.
being deeper instead of closer?
If it's compliant within the rules, I'm obviously smaller is better for me. I'm not sure that they need an oversized garage. If they do, and it's within the boundaries of your construction agreements, so be it. My preference is that it just be further away. I thank you for your consideration.
Anybody else would like to be heard of this application? Therefore, we're going to keep this open, right?
I think that's what they're asking.
Yeah.
Yes. At this point, we're asking that you keep it open until we go back to our clients and let them know your concerns, recommendations.
Okay.
Will we keep this application open for all purposes? Okay.
All in favor?
Aye.
Thank you. Have a good evening.
I believe that takes us down to the new cases. First one being case number 2869, Mark Greenwald, 1361 Meadow Lane.
Ready? Good evening, Bob Herman, Event Consultants. I'm here on behalf of the applicant, Mark Greenwald, tonight. The application that is before you here is for a wetlands permit that would allow the applicant to construct a simple fixed dock consisting of a fixed catwalk and steps to the water that would provide the applicant with a dry, single structural point of access over tidal wetlands and to the Dug Lagoon of Shinnecock Bay that the lagoon connects to further to the west. Similar to the CB&V LLC application that we closed earlier tonight, this proposed dock has been designed with low profile, minimal scope, consisting of a 4-foot by 55-foot long, I should say 4-foot wide by 55-foot long fixed timber catwalk, leading to a set of 4-foot wide by 8-foot long steps that end just seaward of the mean lower low water line. There's approximately 40 linear feet of the total 63 linear feet which equates to approximately 160 square feet of the structure that is landward of mean high water, and the balance of the structure, which is the other 23 linear feet, including the 8 linear feet of steps, totaling 92 square feet that is seaward of mean high water. The catwalk will be constructed with 4x4 posts. The decking will be 60% open grate fiberglass reinforced decking that will be no higher than 26 inches above the elevation of high water, as is required by our Southampton Town Trustees permit. There is no woody vegetation, either upland or wetlands in nature, that would need to be cleared for installation, and that is by design. The location for the dock on this property has been chosen for very specific reasons. First of all, it is located 20 feet off of the easterly property line, which is the same setback as the existing house. I have some photographs that I will show you, and then I'll hand up to you that you can pass around on the boards just to give you a sense of the site and why we've chosen this location for the dock. On the easterly portion of the property is the most lowly elevated side of the waterfront side of the property. And you can see that in this photograph, that as you move west, the slope of the land moves immediately up. Whereas here is a fairly level run that allows us to propose this lowly elevated catwalk. And this picture is a shot looking from the water up toward the house, and this is a shot looking from the beginning of the catwalk down. In this area, it's a little bit wider overall in terms of the width of the wetlands that it would cover, but with respect to wetlands disturbance, you can see from the two photographs that there is a very clear run from the edge of the lawn right down to where the dock ends on the seaward side. Whereas as you move to the west of the property, and this is standing at the location of the proposed dock and looking west, there's a lot more woody vegetation, a lot of wetlands vegetation, Bacchus helmifolia, Iva frutescens, etc. And as you're looking, this is from the west side of the property looking up. So basically, where we show the property to the east is the most lowly elevated section, and it's the clearest section with respect to vegetation. In terms of the setback from the property, there is no requirement under the code for a setback for the catwalk. I did confer with the building department before we filed the application and was told that while there was no setback, it would be at least a common sense rule of 20 feet, which in this case works because the existing house is also set back 20 feet from the property line. That ends up coinciding exactly in this location where the dock works for every other reason related to environmental impact and elevation for the walk. Again, similar to CV&V LLC, there would be very limited information we can offer. I'm going to guess that Mr. Voorhees is going to ask me for a separate construction methodology based on the other hearing, and we can provide that. But again, the idea here is that we have a dock that it's again 4x4 posts, prefab decking, and simple structural timbers, all of which, by the way, will be untreated timbers consistent with the trustees permit. I should note that permits for the project have been obtained from the U.S. Army Corps of Engineers, the New York State DEC, consistency concurrence on the New York State Coastal Management Program provided by the New York State Department of State Coastal Resources Division, and then of course locally by the Southampton trustees. So again, there is no variance we're asking for here. There's no relief we're seeking. As you know, under your code, the catwalks are not subject to a wetland setback, as is a residential structure. They are specifically excluded, along with shoreline structures, from the wetland setback. So we are just here under the environmental nature of asking for the wetland special natural resources special permit. If the board has any questions, or Mr. Voorhees has any other questions, I'm happy to answer them.
Seems to be the season for catwalks.
It does.
Go a long time without getting in, and then we're getting hit. Does the board have any questions?
No. Questions?
Just a couple of comments. I'm familiar with the property. We have looked at permits on this property before. And I wanted to confirm with Rob, or at least have it emphasized for the record, that there's really no removal of vegetation. Certainly no tidal wetland vegetation and no upland buffer vegetation based on the location that they selected. Also, Rob, isn't there a setback in the town trustees that they observe?
There is. There's actually a few different setbacks that apply between the other agencies involved that range from 10 feet to 15 feet in terms of what distance you must be set off of the side property line. The New York State Department of State does typically require a minimum of 15 feet. The trustees require a minimum of 10 feet. So we are exceeding both of those setback requirements here.
And I think that was a point that would be helpful also on the record. Rob, I was looking at the cross-section, and there's a reference to 27 inches above water, and there's like an extra line there. And I just wasn't clear where the 27 inches is referring to.
26.
26 inches.
Yeah.
Okay, so
That
that's
one there.
high water up to the
Right.
top surface of
Yeah,
the
the Southampton trustees now, as a general policy on their permits, want the top of the decking to be no higher than 26 inches above the elevation of high water. And the reason for that is sometimes, well, I shouldn't say sometimes, all the time the other agencies, particularly the DEC, want the landward section of the dock to be elevated a certain height above wetland vegetation. And so what used to happen is the dock builders would start a level line and just keep that going out, so that by the time you got out over high water, the structure was, 3, 4, 5 feet above high water and very intrusive aesthetically. So what they have required now is that structures, even if you have to go out a certain height, get ramped down or stepped down or somehow brought down over the open water so that you're only 26 inches above. In this case, there really is no dock component that extends out over the water. I mean, there's basically a set of 8-foot steps which start about a foot landward of mean lower low water. So at even at a mean lower low tide, you've got 7 linear feet of steps that are over the water. But in order to comply with the trustees' requirements, we are still showing that maximum elevation. And what Chick is referring to is when you get out right landward of the steps, from the elevation of high water to the top of the decking can be no more than 2 feet 2 inches. I don't know how they came up with 2 feet 2 inches, but that's what the requirement is, and that's what's specifically required in the trustees' permit that was issued here.
So the point being that it's a low elevation structure, it's situated farther from the property line, and it's in an area with no vegetation impacted. And as Rob observed, we have found it helpful to have the applicants think about construction just for courtesies to the neighbors and making sure that equipment and staging takes place off the road. So I would make that request, and other than that, I had no comments.
Is there anyone out in the public like to hear this application?
Good evening. My name is Brian Lester, Tarbert and Lester, 524 Montauk Highway, Amagansett, New York. I represent Mr. Golub, the neighbor that's sitting, if you're looking from the road, right to the right, the neighbor that's going to be closest to this catwalk structure. I have a memo that I've put together based upon the limited information I had within the application. More information has been told to us tonight, so I'm going to ask for further time to comment onto that information as to where they put the placement of the catwalk based upon their information they provided tonight. We're seeking not to prohibit this catwalk, but to ask that it be moved further to the left towards the pool. I guess that's west. The fact being it is closest to my client's property, affects his vista, which is one of the principles that the code requires you guys to look at. It also, as the applicant noted, it is placed at the widest point of the wetland is where this catwalk is placed. There is a greater distance between the homes on the other side, as well as the recreational area of the pool already placed there. This would keep the recreational areas together. We would also ask that any restrictions be placed on this catwalk that be restricted to non-motorized watercraft, and ask that there be revegetation buffer put in. If you notice, this house is the only house along that road that has substantial grass area between the house and the wetlands area. I'll let you read my memo, but I ask for further time so I can comment as to their location specificities and put in appropriate comments as to that. Thank you.
Do you by any chance have an extra copy
Yes,
of your memo?
I do.
There's one up here, too.
And I'll give one to the applicant as well. Sorry.
Thank you.
Is there anyone else in the public like to hear this application?
May I offer just a quick response? I just want to note for the record that we have been in the application process for several months, and during the public notice period from the Department of the Army, Mr. Lester submitted a similar letter with similar comments dated December 19, 2014, and it's now almost May. So the only thing I would suggest is I would object to the idea that he or Mr. Golub have somehow not had enough time to look at this. The project has not changed since the day we submitted it. It is the same now as it was 4 months ago in December. I don't really have anything to add with respect to why the location of the dock has been chosen, unless the board would wish me to go over anything else. I think the issues in terms of the elevation of the dock, the fact that this is the place on the property where we can locate the dock where we don't have to disturb wetland vegetation, those are really the things that the board wants to be concerned about in a wetlands application. And we would ask you to focus on the merits of the application as it relates to wetlands and environmental impact.
I do have a question. The lot immediately to the west, it's a non-buildable lot, isn't that? The wetlands comes in strongly on that side?
Is the property to the west an unbuildable lot?
Yeah, in other words, is there a house there?
I could have sworn there was.
You mean the east?
Mr. Golub's property is directly to the east and to the west. Yeah, that was isn't that the Hickey property? I think this board had heard an application for renovations on the Hickey property not very long ago, maybe 3 years ago.
Yeah, I misunderstood.
No, that's okay.
I thought there was wetlands that sort of came in closer to the road on that.
No, not here.
Okay.
No.
Dug those lagoons. They're always called dug lagoons. I don't know who dug them.
It's the same lagoon.
Huh?
It's the same lagoon. It spans a number of properties.
Like that.
Who dug it?
Rather nice, really.
Somebody who wanted waterfront.
I guess so. Well, they have waterfront. They're on Shinnecock Bay.
Well, what would they have? They'd have a little more.
Yeah.
Just in view of some of the comments, and I haven't had a chance to read this yet, would the applicant consider additional vegetative buffer to supplement the existing buffer?
Similar to what we just did on the other application. Yeah, I mean, if that was a condition of the permit, I'm sure the board will recall that a number of years ago, I don't know how many years ago it is now, maybe 6, Mr. Greenwald was in front of this board and we had variance relief and extensive revegetation plans. The property in the back really is quite well vegetated. I mean, there's certainly no extensive lawn that exists in the back, and nothing that exists that shouldn't exist based on the prior variance approval. But similar to what we just did with CV&V LLC, if there's room to add some supplemental plantings around the dock, if perhaps up on the landward side that would somehow help to shield the view of the dock or something. I mean, I had originally gotten a call from Mr. Golub, again, during this Department of the Army process. And he called and he told me he didn't like the fact that the catwalk was going to be too close to his swimming pool. So I'm not sure exactly what the concern is. That it's the same setback as the house. Mr. Greenwald's house is, I mean, I would have to say quite a bit closer to Mr. Golub's house and his swimming pool than his dock is. But if there is something else, if it's you know, having to see it or look at it or whatever, certainly we can have some supplemental plannings that would be appropriate for that location. You know, again, there's really vegetation on both sides of this pathway. This is the place where historically, and I don't know if Mark wants to comment to this, but I think even prior to Mark's ownership has always really been used as the point of access to the water here. Even if you just went to this property to drag a kayak down through the vegetated marsh and get to the lagoon and out to the bay, this is where you would go. So again, you know, this issue was raised months ago. We addressed it with the Department of the Army, and the Department of the Army and the other agencies all, through issuance of their permit, ultimately agreed with us that this is under best management practices or any other environmental justification. This is the location on this property. I mean, you could walk blindly onto this property and you're going to point to this spot. And in terms of the setback from Mr. Golub's property, again, we were careful to make sure that we not only met but exceeded the offset requirements of every other agency involved, and there's 4 of them aside from you all, and conferred with the building department to make sure that we would comport with whatever would be required once we hopefully can get this board's blessing and move to the building department. So this is not something that we just arbitrarily stuck here, you know, in spite of Mr. Golub's concerns of the property. This is a decision that was made based on the objective standards that every agency that's involved here looks at.
Is the walk the same distance from the easterly line as the house, or is it further than the house?
It's the same. So the house is set back 20 feet from the easterly property line. The catwalk is set back 20 feet from the easterly property line. So if you were looking right down the easterly facade of the house, you have a straight run from the corner of the house to the corner of the catwalk.
It goes right between those 2 flags there, right?
That's correct. And I can submit, you know, paper copies of those photographs for the record. I know the ones I was handing around just for ease of passing around is on cardboard, but I can submit paper photos so you have them for the file.
I was down there today. I could see where.
Oh, you were? Okay, great. Good.
So far as the grass, there is grass there, but it's not that wide
No.
a strip of grass. It's
Nope.
just off the back of the houses. I don't know how wide it is. It can't be very wide.
No.
15 feet, maybe 20.
Yeah, it's not. I mean, there's just not much to the yard
No.
behind the house. There is a naturally vegetated slope that once you hit that point, it runs down. But again, if there is any sort of supplemental planning we can do around there, I mean, I don't know why Mark would object to that.
I would think if you did some more planting, that would further get in his view of Mr. Golub.
Yeah, that's why I said
He's looking out straight over a flat catwalk.
Right. Well, that's why I'm saying I don't fully understand what the concern is, but we've tried to, as I said, address our proposal in the right way.
We have any other comments from the board? You want to finish, Dick? We've already had comments from the public. Rick,
No questions?
you want to close the decision, or you want to keep it open at the request of the other attorney? To me, I think we've heard enough, and I think they've had the 4 months to respond to this.
It's up to you.
I just assume we have a closed decision.
I move we close this application for decision.
I'll second.
All in favor?
Aye.
Thank you.
You done?
I think we are. On my end. You want me to stay?
Half a day?
Isn't this one down here, isn't this yours?
No, I think
Last
they switched
one-
the orders
the
so
last one on the agenda?
that I could get out
You
early.
have a hole at the office, don't you?
Have a good night, everyone.
Okay.
Aye.
On the application of case number 2870, Douglas Taylor, 101 First McLean.
Maybe it was just similar.
Yeah, it was this similar one in the same road.
The applicant Gilbert B. Flanagan, 21 South Main Street, Southampton. I have an affidavit of posting and an affidavit of mailing for the record. You may recognize this property in this project because you actually heard an application 2 years ago for variances to permit its construction. And I'm back here this evening because, due to a builder's error, the tennis court was not put in exactly the location which you approved. I submit that it is a builder's error, but I would ask that, as far as the underlying purpose for the variance originally granted, that you incorporate into this record the information and testimony that was presented at the 2013 hearing, which you rendered a decision on May 23rd. You may recall from your decision, which I submitted as a part of my application package, the variance was a variance to 42 feet from the easterly property line and showed a setback of 40 feet from the northerly property line. In fact, as constructed, the court was constructed at a 35.4-foot setback from the east line and a 35.1-foot setback from the north property line. Now, you might wonder what prompted us to bring this application. It's important to note, as the file indicates, as I submitted, that the village actually issued a certificate of occupancy for the tennis court. It came to our attention because my client was refinancing the property and needed to get an updated survey. He had no idea that it wasn't built where the tennis court variance was granted. He had no knowledge. I don't think anybody, especially even the village, had knowledge of the problem. And quite frankly, we could have let things go. We had a C of O. We could have let things go, but on our advice, our client agreed that we should make things right, and that's why I'm here before you. There was no attempt on the part of the applicant to do anything wrong. In fact, the applicant is absolutely shattered by the whole experience. You may remember that as part of the application I submitted, I made reference to a planning board site plan approval, which was also granted for the court after you granted the variance. That planning board site plan was prepared in part by Century Tennis, which was the company that installed the court. And I didn't submit with the application the map that was part of that application, but I will now. And it clearly shows, as proposed, the tennis court observing the 42-foot setback from the east and the 40-foot setback from the north. So I'll submit that. I have a full copy, and then I have copies of just the relevant section of the site plan. And the building permit was issued based on those plans also. So it was always my client's intention to build what was approved by the variance. I think what happened clearly is a mistake, as far as we can tell, on the part of Century Tennis. And I have a memo from Seacoast Builders. I believe you noticed in the file I submitted an estimate of costs to correct the condition. Seacoast is my client's general contractor, and he looked into the matter of what could possibly have happened. I think that there may have been some internal problems with Century Tennis. There were two partners. I think one of them died during the course of this project. And I have a memo which the general contractor prepared. Unfortunately, he had planned to be here tonight, but a medical situation in his family prevented him from being here. But I asked him to jot down a chronology and his understanding of what happened, and I'll submit copies of that for the record. And one thing I'll mention, which I mentioned at the 2013 hearing, is the situation in the immediate neighborhood. You may recall that at that point I submitted a 200-foot radius map which showed the development which was then around the subject property. And since then I have gone on Google Earth, and unfortunately we could print only a certain size, but what it shows relevant is the subject property and the properties surrounding it. And as you can see, and as I pointed out previously, the tennis court as installed is directly opposite the tennis court on the property to the east, and there is substantial vegetation between the two of them. I might also point out, as I pointed out at the hearing in 2013, that the tennis court to the east enjoys a 30-foot setback from the property line, which is actually closer than my client's tennis court as built. You can see 101 Toilsome Lane is starred here, and you can see the property to the east. It's important to note that on the property to the north, there's nothing. So I would submit that there would be no adverse impact on the neighborhood by virtue of this fact. I don't know that I have to say too much more about this application. It is a builder's error. My client intended to build according to the variance. That's what all the permits were issued for. That's what was applied for. I don't think anybody knew that the court was 6-something feet closer to the east line than it should have been. From what I understand, there were never any complaints about it. It was used during the latter part of the summer of 2013. It was used all last year. I don't think there were any adverse effects as far as I can tell. Part of the submission, I think, is telling what I made, and that is that you have to consider the balancing test, which the law now requires. You weigh the benefit to the applicant versus the detriment to the neighborhood and to the neighbors. Well, I think that what I've said so far really indicates that as far as we can see, there really is no detriment to the neighborhood. But in order to correct the condition, the economic impact to my client would be on the order of $200,000 according to the information submitted. And that's in part due to the fact that, as you know, the tennis court had to be sunk in accordance with the village code. It is also what I understand is called a hydro court, so there was irrigation placed underneath it. The landscaping would have to be redone. My client got estimates from 2 tennis court people as to what it would cost just to do the court work, and the number that's in the estimate you got is the lower number of the 2. Hampton's Tennis came up with even a higher number. So I would submit that to require this court to be dug out and moved over 6 feet at a cost of over $200,000 would not exactly meet the balancing test.
Century's estimate was lower, I imagine?
Yes, Century's was lower, yeah, but not by much, by about 6,000. I think the Century's number is the number that we submitted.
Only
the number we got from Hampton's Tennis was about $150,000, just for the court work, not for the associated landscaping, and we have to remove the retaining walls.
Do it for free, I guess.
Yeah, but apparently there were 2 brothers that ran Century Tennis, and I happen to know one of them, and apparently right at the time that this happened, one of them died right in the other one's arm. So that could account for why it was a mistake. But I wasn't there, so I don't know.
When the project was done, did they have a final survey done that they submitted for the CO?
I don't think they did. In fact, the CO.
They get the final CO without.
I can't answer for the building.
So there is, like in the building department's file, you couldn't find a copy of a final.
No, in fact, we actually, when we did the refinance, that was the reason for an updated survey, which we got, and so that's when we found out about it. If we had just relied on the C of O, probably nobody would have known about this for years, if ever. But here we are to try to make it right.
I walked along the property line, and the screening is so dense. In fact, there's more than one set of screening. There's a fence, and there's 2 sets of screening it, but I couldn't even tell what was next door.
Well, that's part of the point. I think the aerial photograph shows that. And if you look at this situation, too, this is an unusual lot because it's a flagpole lot which has a private road next to it. Under normal circumstances, this would either be a side or a rear yard, and then it would conform. Because with the size of this lot, the setback would be 30 feet. So we would actually more than conform if this weren't such an unusual lot situation. So I don't think I can say too much more about it. I request that you act kindly.
Do you have any comments? Rick?
No questions?
Anybody out in the public wish to be heard of this application?
Hi, good evening. My name's John Lowy. My law office is at 645 Fifth Avenue in New York. I am the attorney and also husband of Barbara Lowy, who is on the east side of the Taylor property. In brief history, when this first variance was requested 2 years ago, we honestly wanted the property, the tennis court, to be perhaps 65 or 70 feet away from ours. Notwithstanding, we negotiated with Mr. Flanagan, and we agreed that 42 feet would be acceptable. As you have pointed out, and we have all the records that there was what was submitted to the board was a 42-foot boundary, 42-foot setback. We cannot explain why it's only 35 feet. As you said, no survey was done. Somehow a certificate of occupancy was granted. We have no knowledge except that we feel that we have been prejudiced by this. We also point out, Mr. Flanagan just pointed out vegetation. There's a lot of vegetation, but that's on our property. The variance called for evergreens around the tennis court, to the best of my, and a fence. To the best of my knowledge, neither has been put up. So what we have here is a situation that nothing has been complied with from the original variance, and now Mr. Taylor comes in and wants a variance to his variance, when the first variance was not complied with. And we, as the neighbors, we feel we've been prejudiced because, among other things, Mr. Taylor's property is now on the market. So while it's possible that there has not been noise the last summer, what happens when the property is sold to someone who has 5 children? We don't know. But what we have asked for is originally 42. Actually, we asked for originally about 70 feet setback. And as I said, we negotiated in good faith. We agreed on 42 feet, but nothing has been complied with, even including lack of vegetation around the court.
Can I ask Mr. Flanagan if that's your understanding? Was there vegetation?
What I was told, and I haven't physically looked at it, what I was told is that some of the vegetation was planted and it deceased. So my client has every intention of replacing it and complying.
Yeah.
Obviously, the village, when the village issued a C of O, they must have been, presumably they were satisfied with it, but to the extent that plantings are required, they will be put in exactly as required by the planning board.
You can see around the tennis court that there is some area that looked like it had been dug up. It didn't match the lawn.
No,
right up against the tennis court. You can see
I was told that there had been plantings and that they didn't survive and they had to be replanted. That's what I've been
Well,
told.
we have a photograph. As I said, the property is on the market. We have a photograph, which is in several of the magazines, and you can see there's been no vegetation put around the court.
I have a question for...
Just so you know, if this board grants a variance, then they still have to go to the planning board to revise the planning board's site and landscape plan approval. And the planning board normally considers landscaping, that's part of the planning board approval process, is not only site plan approval, but also landscape plan approval. So that will come up before the planning board if they get past this board.
Yeah. Might I also add that if in fact it was the builder's error, then the builder should take care of this. Why should we be prejudiced?
Well, I have a question for you. If the present owner of this illegal tennis court were to do additional planting, so between his tennis court, like if we were to grant the variance, but only if he did additional screening and planting heavily between your property and his, would that be a compromise that you would be able to accept?
Well, I would certainly discuss that with my client, my wife. I'm not ruling it out, but I certainly like to know exactly, number one, what additional vegetation would be put in and when it's going to be put in. In other words, is it going to be complied with, so that we don't have to come back here again seeking another variance.
It seems that you could ask for like double. I mean, towards the court and towards your property line. You could ask for,
by the way, excuse me.
Excessive vegetation almost. Excessive
Well,
vegetation.
the original plan, which was approved, calls for 2 sets of hedges next to each other, 4 feet high.
Hedges don't die around here very
Well, they were evergreens. They were evergreens, yeah. And there were supposed to be 2 rows of them, 4 feet high, and as I said,
Well,
we have a photograph showing nothing.
Maybe what they need is, if it's 2 rows, but instead of 4 feet high, because if they had complied and they had 4 foot high, by now it'd probably be 7 or 8 feet high. So, you know, if they do screening now, it should be at the full growth height, not starting at 4 feet again, you know?
Well, they did sink the court. The court is down 2 or 3 feet, whatever it is.
No, I understand that.
Oh, yeah, and the
Sound and screening purposes of.
There was also supposed to be a fence also around the court, so.
You mean just around the court, not the one that's on the property line?
Yeah, around the court.
Around the court.
Yes.
It's like the LIPA
Bill, do
vegetation.
you have anything
they're
else
gonna
to
put in.
add to this?
What the planning board typically requires is a double staggered row of evergreens. I'm sure that we would do at least that. That's no problem. If this board decides to act favorably and it makes a recommendation to the planning board, that's something else that we can live with. But as you pointed out, the court is sunk, I think, more than 4 feet below grades, and as you know, the height of a tennis court fence can only be 8 feet high along the sides, along the ends rather. Along the sides it can only be 4 feet high, so you're talking about a maximum of 4 feet in height along the ends and 20 feet down the sides. So even a 4-foot planting would totally screen would screen the fence. If you wanted something that was a foot higher or something like that, I can't imagine that being a problem.
Maybe use a different landscaper.
I'm looking at the planning board approval that's in our file, dated June 3, 2013. And it talks about a double row of evergreen trees, a minimum of 5 feet tall, at planting space 4 feet apart on center. And also a chain link fence 4 feet in height around the court. And it does refer to a landscape plan that was before the planning board. You know, if you want, you could ask the applicant to provide you with copies of that landscape plan that was previously approved, so you'll know what is supposed to be there and whether you want to ask for more.
I wonder if your client has copies of receipts to these landscapers outlining what they did.
Certainly, I can ask them.
Well, as I said,
Usually stuff doesn't die that easy, so I'd like to know what they planted there that didn't last. I don't think we'd want the same thing again.
Did you ever see any 5-foot plantings?
no, no, nothing. And again, it was supposed to be evergreens, so they last.
It's obvious that has to be complied with.
It would be nice if we could make it better and, reduce your decibel exposure and everything else. If we could make it better than it was supposed to be.
Well, it would certainly help if there were plantings there, and as I said, they were at least 4 feet high, and there was a fence, and it was done promptly.
Just to say, just in terms of the fencing, the code does limit what you can do on a tennis court fence, as you probably know.
Yeah.
Right.
So along the sides, there won't be any fence visible because it'll all be, the maximum height of a fence from the surface of a court is 4 feet. And since the thing is sunk more than 4 feet, you won't even see that fence. It's really the ends.
If the vegetation lasts.
If there's vegetation. So again, as Mr. Peters pointed out, the planning board already required the plantings to be a foot higher than the fence at the ends and 20 feet down the sides. But I would be happy to get you a copy of that landscape plan. I have one here, but I'll obviously make more copies for you.
And why don't you think about whether you want to propose something greater?
I can do that too.
Because the board is interested in that.
I think I'd want this landscape plan to specify 4 feet apart, what kind of trees that they're going to be, if they're going to use a couple of different varieties, 5 feet high, maybe a little higher, a little fuller, because that 4 feet high tree and 4 feet apart, there's going to already be gaps between them. So maybe they should plant it so everything is tight, like it would have grown in the last 2 years.
Okay.
So are we asking for a landscaper to come with a plan?
I
Or
think
is that
that we
the planning board?
I think you're asking for one.
We are asking for
Yeah, we're
one
asking for
instead
it, yeah.
of just a
We're asking for
I mean,
promise.
it'll go to the planning board, but they won't say it's the minimum of what we would
Yeah, in other words,
require.
we just don't want somebody's promising to do it.
No, no.
Yeah.
we
No,
want-
you can impose a condition that
Plan.
it be at
Yes.
least this,
Yes.
and then if the planning board wants even more, the planning board can do more.
You certainly do. I have no problem with getting that for you.
Yes, as Susan was pointing out, yes, if it had been done properly, as you say, they'd probably be at least 6, 7 feet high by now. So we request then, let's assume that it was done 2 years ago, so hopefully what will be planted now will be, what, or 5 or 6 feet high?
Yeah, that was my point. It
Yeah,
would be fuller
it's a
and,
good point, yep,
I'll certainly go back to the line with that.
yes.
Reminds me of the LIPA vegetation plan, where they're gonna have big evergreens all along that wall on North Sea. They got 5 dead trees 4 feet high there.
And the plan did call for 2 rows of vegetation.
maybe they should be, I don't know if those other trees were irrigated too. So, you know, I assume when they did the work, they did a sprinkler system, but,
I'll find out about that.
Yeah.
I know exactly what you want, and I'll get it for you,
All right, so we'll have to hold this open.
please.
Okay.
Anyone else wish to be heard of this application? So, we'll hold this open for all purposes.
So moved.
second?
All in favor?
Aye.
You could see something further there.
In this case, I guess.
Yeah, that's what I'm saying, man.
Pulled it out. So, yeah, 2871. On the application of case number 2871, William Solomon, 784 Meadow Lane.
And here I thought this would be the first and only application on a tennis court here this evening. So it was very painful to listen to the preceding application. I feel like I have to prove I'm saying, I really mean what I'm saying. So in any event, Anthony Tohill, 12 First Street, Riverhead, New York, representing the applicant. We've handed up the affidavits of posting and mailing. I'm here tonight accompanied by Lisa Poyer of InterScience and by Tim Rumpf from Aries Design. This is an application to enable the placement of a tennis court within a front yard at 784 Meadow Lane, which, as you know, is an oceanfront parcel. We have in the record already 12 photographs that were prepared by Lisa Poyer, and I'd like, if I could, to ask you if you just look at them for a minute. The first two on the photos numbers 1 and 2, they depict the existing conditions looking first to the west and then to the east along Meadow Lane. And the purpose of showing you these is to explain that the intended result here will be the exact same as what you see. If you turn the page to photograph number 3, you'll see the existing driveway with the cattle grate. If you were down there, you'll know that it's not easy to get through there. That driveway will be removed. And then you have also, as part of the record, a Tim Rumpf drawing, multiple pages, which depicts the easterly relocation of the driveway. When that happens, the existing driveway depicted in photo number 3 will be revegetated so that that area will look like photo number 4, which is the existing roadside appearance a bit to the west, or to the east rather, of the existing driveway. If you look at photograph number 6 on the third page, that shows a cleared area. That's actually the driveway, the parking area adjacent to the house, the landward side of the house. So when you come up the hill across the cattle grate, that's the parking area at the end of the driveway. That's the proposed location of the proposed tennis court. So it's going to be in that exact same location. The next set of drawings, or rather photographs, are 7 and 8, but then on photograph number 10, which shows burlap encasing what must be plants, now that burlap has been removed, and that photograph number 10 is adjacent the Liss property, Harry Liss property, which is our westerly boundary. And within that burlap, you can't see it, but down there you can today if you go down. There are mature Leland cypress, probably 12 to 14 feet, all along that common boundary. I'm mentioning that because if you turn to photograph number 11, which is labeled as if it were along the east boundary line, that is the reverse. The photographs were mixed up. Both sides, both the east boundary and the west boundary, are now improved with very mature Leland cypress that are in good shape. If this application is approved, and Tim Rump will explain this a little bit further, the intention is that we're going to add to that line of Leland cypress another line on each side of 12-foot-high evergreen Hollywood junipers. So we're going to have a double row of evergreen plantings on each of the sides, the east side and the west side. Here is an aerial photograph showing the location marked in yellow of the proposed property. And Lisa Poyer is handing up to each of you an individual copy of this drawing. By my count, and I'm not sure how well my eyes are doing this, but I think other than 784 Meadow Lane, there are 9 houses shown on the ocean here. And I think it's actually easier to see the tennis courts than it is the houses, or the separate houses. Yeah. 6 of those 9 houses already have tennis courts. So there is a bit of a character to the neighborhood that has been established already. In fact,
I didn't see the stand.
Can you see it?
Oh.
Yeah. In fact, yes, by actual count, and we've done this, there are some 42 tennis courts on the south side of Meadow Lane, the ocean side of Meadow Lane at this time. You've actually approved 44. 2 were not built, but there are 42 in existence there today. The average setback from the street to the tennis court is 75 feet. This proposed tennis court would be at 90 feet. So it's more than the actual average that's there.
So it's in the front yard, but not the required front yard.
That's right. Yeah. This tennis court will be sunk, and it will be surrounded, this is important, it will be surrounded by a double row of evergreen 5-foot ilex that Tim Rump will be able to explain, which will be irrigated. We're going to mention to the proposed owner of this property what we just heard, including having the surveyor there to stake and monitor the construction of the tennis court and to make sure that the plants, once planted, grow as the planning board will require if we're successful here this evening. There are no wetlands within any regulated distance. The westerly neighbor, who I've mentioned earlier, Harry Liss, has explained that he has no objection to this application. So he's the one that would be most affected to the extent the tennis court would be on his side. There will be no lights on the tennis court. To the extent that the residence, the estate of William Solomon, is there for many years, and to the extent that there's a coastal erosion hazard line right along the seaward edge of that existing residence, we have, and this is typical of all of these cases, no reasonable or feasible alternative that we could employ. It's not the introduction of an undesirable change in the neighborhood. You already see the neighborhood in the photograph that Lisa Poyer has handed up, but I'm also going to hand up at this time 7 copies of a compilation of one document is a single page marked Exhibit A. No, it's Exhibit 8. One document is a single page marked Exhibit B, which is a listing of all the approvals through all the years. And then Exhibit A is a Xerox copy of 25 plus or minus decisions, which is sort of interesting to see. They go back to a time in history when each of us had a full head of hair, and there are a lot of names in those decisions that will bring back memories of people that we all know were new, some of them not here anymore. But there's 40 plus years of decisions on tennis courts on Meadow Lane. So I think between the photograph, the aerial photograph, Exhibit A and Exhibit B, it's pretty clear that any grant of relief here would not be the introduction of an undesirable change in the neighborhood. It would actually be completely consistent with the neighborhood. There's no environmental impact, or none that I can imagine. If the tennis court is sunk, it will be self-draining. The noise is attenuated by reason of sinking the tennis court, but also by reason of the double row of ilex. There are no lights, and the entire proposal is concealed in every direction by extensive landscaping. As I mentioned earlier, there's not a self-created hardship here because, on the one hand, this is the nominal applicant is the estate of William Solomon, but the real applicant is the contract vendee who wishes to buy the property and has children and wishes to enjoy the benefits of a tennis court. If you have any questions, I can answer them right now. Otherwise, my intention was to yield the podium to Tim Rumpf, and then I'll stay here and answer any questions that you might have at the end of Tim's presentation.
Mr. Chairman, members of the board, council, Tim Rumpf from Aris Design, located at 38 Nugent Street, Southampton, for the applicant. What I would like to do is to hand up to the board a minor change or change in the site plans that we submitted with the application. And the real change is the elevation of the tennis court. This is a projected site plan or conceptual plan for the entire front yard. Mr. Tohill had talked about the relocation of the driveway and the addition of a parking court, which would allow us to put the tennis court in the location that is in front of you at this point. The proposed tennis court elevation is to be elevation 10. The retaining wall that will be built around the tennis court will, at the height of it, the majority of it will be at elevation 14. As we get closer to the house, there'll be another retaining wall stepping back from that, which will be at elevation 18. Part of, if you look at that existing site plan or the existing conditions or have been to the site, there's a little knoll in that area as you get just to the east of the existing parking court. We're going to drop that and use that material to spread, to create a little level playing court or a little courtyard, level courtyard in this area as well. Mr. Tohill talked about the Hollywood junipers that we're going to add along the western property line as well as along the eastern property line as part of the relocation of the driveway and the service court. We have designed the court to meet the criteria of the planning board for their tennis court permits. Obviously, if this board grants the variance for the court, we will be going to the planning board for their approval. Within that package, we've shown the drainage that we propose. We will be draining the court crosswise from this side to, and our drainage will be picked up here. You'll notice that there are dry wells that are being located in this general area. So we've already kind of conceptually prepared that, so we knew that this location would work for us. And that's basically also, if you've been to the site, the vegetation, some of the vegetation there is wonderful. We're going to hope to replant and transplant that vegetation as we prepare and move the soil around and create the courtyards. So we're going to be stockpiling that material on site and then replanting it as part of this application. Are there any questions or anything else I can illuminate on for the board? I'm happy to do that.
Any else? Questions? Rick?
No questions?
As this new work progresses, is there any existing like septic systems or anything like that that are going to have to get relocated? Or is everything just grading, you know, to...
I'll let Lisa answer.
Lisa Poyer with Inner Science, on behalf of the applicant. As you can see here, the sanitary system is on this side of the property, so any work associated with the tennis court won't impact the existing sanitary system.
And that's already existing the way that
Yes.
is? Okay.
It's over in this corner.
Anyone out in the audience like to heard of this application?
Good. Applicant requests a front yard variance in order to permit a proposed tennis court in a front yard between the house and the street, period. The proposed tennis court will conform with the minimum street setback requirement of 90 feet for an accessory structure, period. This application is consistent with our practice and policy regarding accessory structures in a front yard on oceanfront parcels, and this application is consistent with the character of the neighborhood, period. Therefore, we grant the requested variance, subject to obtaining site and landscape plan approval from the planning board.
I move we accept this decision as proposed.
Second, all in favor?
Aye.
You almost gave me too much stuff, Tony. I was almost going to put it off.
I actually felt bad for you.
Here's a lot of stuff, that's for sure.
He did his homework, that's for sure.
Oh, he goes.
I don't think it's indexed by computer either. Unless John has a list somewhere.
On the application of case number 2872, Joyce Lee Rogalin, 31 Bailey Road.
Hello, I'm Linda Riley, 235 Hampton Road, for the applicant, Joyce Lee Rogalin. I'm passing up affidavits of posting and mailing. This applicant seeks to remodel an existing house by adding a second story over a portion of the first floor footprint, and by adding a one-story addition at the back of the house, and by filling in a very small indentation at the front of the house. The lot was created as a result of a 1989 subdivision, which divided a larger lot into two equally sized lots. The other lot lies adjacent on the east side. And in essence, this proposal is to remodel the existing ranch house on this lot so that it will be very similar in many respects to the existing house on the mirror image lot that was the sister on this subdivision. I have to pass up to the board a packet which includes a picture in the front of the adjacent house on the sister lot, and behind it some of the things from the building department's file that relate to that house. Before the subdivision was granted, the Zoning Board of Appeals granted variance relief for both of these lots, a copy of which was attached as Exhibit A to the application that was submitted initially. And the relief that was granted by the ZBA included front yard setback relief to 34 feet for both lots. This was done, and the decision says as much because there was really only 8 feet worth of depth under the in a permitted building lot as it was under the law at the time. So they granted both lots what I would call almost a blanket variance for 34 feet. The survey that was submitted in connection with that variance application is attached to our application as Exhibit B, and it depicted 2 identical rectangular blocks for the houses. No specific plans for the houses were submitted or reviewed in connection with either of the lots in the original subdivision application or the variance application that preceded it. Nothing in the record before the ZBA indicated that the houses would only be 1 story, and the front yard variance is in no way conditioned on the houses being no more than 1 story. Thus, it's our argument that the original variance granted the relief that would allow the 2nd-story addition that is proposed now. Similarly, the 1-story addition behind the existing house is also benefited from the prior grant of a 34-foot front yard setback. Indeed, front yard variance relief was not required when a 2nd story was added in 2005 to the house on the mirroring lot, and for that matter, the addition of an attached garage at the same front yard setback. So the garage and the connecting sort of enclosed section between the garage and the house next door and the entire 2nd story on the house next door was added without any requirement for front yard setback relief, which I would argue was because there had already been a variance granted to the 34-foot front yard setback. The only variance relief required on the adjacent lot was for a rear yard variance to allow a 1-story addition at the back of the house. And that variance, or at least as much as was contained in the village's file, is attached to that hand-up I just gave you. Unfortunately, there was no decision in the variance files whatsoever for that, but the front of the envelope and the application and the survey all point to a rear yard variance only. The existing floor area of the house is 1,968 square feet. Our proposed first floor additional square footage is only 360 square feet, and the proposed 2nd floor, which will only cover a portion of the existing footprint of the 1st floor, is 1,248 square feet. When we brought this up at the building department and discussed all of this, we were told that there would also be an issue about the 50% relief, because what we're proposing here does in fact exceed 50%. But our submission is that this is different than a different set of circumstances entirely, and in fact probably I think that section 116C1 does not apply, because that all refers to the date when a structure became nonconforming. This was never a structure that became nonconforming. It wasn't constructed and then caught up in a shift in law or an upzoning. Rather, this was something that from the get-go was built according and pursuant to a variance. The variance allowed 34 feet, and that's what we're asking for today, to continue it at 34 feet.
So you're saying that you're here, but you don't really think that you need to be here?
Well, the building inspector thinks we need to be here, so we need to be here.
Exceeding 50%, right?
Well, she says that doesn't apply. difference of opinion there.
Even if it is a variance situation, and even if you find that we do need another small point I want to make, actually, in terms of whether or not the variance that was granted originally back in 1987 is confined to, you know, the little rectangles that are shown on the survey at that time, is this house in the beginning was 60 feet long, 60 feet along the road, 60 feet wide. And those blocks on the survey show 55 feet. So right from the get-go, it was a different shape and a longer distance than that what was shown on the surveys. Even if it is a variance situation that we are looking at here, we submit that it meets all of the tests and the criteria for granting a variance. There will be no undesirable change in the character of the neighborhood and no detriment to nearby properties. And our argument there is based not only on the fact that the house immediately next door is pretty much exactly what we want to build, but also based on the neighborhood generally. I'm going to also pass up a small map that shows the footprints, only the footprints of houses along Bailey Road. I didn't even take into consideration the houses on the other side of Bailey Road, which don't have Bailey Road addresses. They come off of Artist Colony Road. Those are huge houses. And in fact, what is directly across the street from us on Bailey Road is tennis courts for the houses that front on Artist Colony Road. All of those are much larger houses than what is proposed here. But even on the houses that actually take access off of Bailey Road, 5 out of the 9 improved lots on that side of Bailey Road contain 2-story homes of a similar size. And as you can see from that handout, many of them are at a similar setback. The ones that have the address put on them, the address numbers written below the footprints, are the addresses of the houses with 2 stories. Also, I did get calls from immediate neighbors prior to coming here tonight. I got a letter from Albert Robertson, who you may know, and he told me that he has no objection to the variance and invited me to say so and recite that to the board. I also got a call from the immediate neighbor to the east, the other side. That man is named James Begley, and his only concern was that he's got his house rented out for the summer, and he wanted to be assured that there would be no construction during the summer while his tenant is there. And I promised him and put it in writing that there is no proposed construction this summer. And he was satisfied and wished us luck. Going down the criteria, besides the character of the neighborhood, we're going to show you now a copy of the survey that was submitted with the application, but on this one, we have highlighted the permitted building envelope. As you can see, it is just a mere sliver in the middle of the lot that is the permitted building envelope here. Interestingly, when the house with its current foundation is set at a 70-yard rear yard setback, which is more than is required now, but that was the law at 1987 when the variance was granted. So the foundation was located at the minimum rear yard setback of 70 feet then. And all we're seeking to do here is build on top of the existing footprint, because to build out 10 feet the back would be extremely expensive to not utilize the existing foundation. Given the constraints of the building envelope and the existing structures that are already on the property, including, importantly, the foundation, we submit that there is no feasible way for the applicant to achieve this goal of having, you know, a larger house in keeping with the neighborhood, other than seeking this relief. There's going to be no adverse effect or impact on the physical or environmental conditions in the neighborhood. There are no wetlands or other unique or sensitive environmental conditions. And the final criteria the board should consider is whether the alleged difficulty is self-created. The applicant purchased this property with the 34-foot front yard variance in place. But again, I would argue that they had a reasonable expectation that they would be allowed to expand as long as the 34-foot setback was respected, as it is. I have with me tonight the architect, Debbie Knopf, who has actually a physical, I'm going to ask her to come up now. She has a physical three-dimensional model of the building that'll show you what portion of the building is existing now and what's proposed to be added. Debbie?
Hi, I'm Debbie Croft. I'm the architect. And this is the lot. This is Bailey Street. And this is the existing house. It's a very long, rambling ranch. So the proposal is, and as Linda pointed out, my client, you know, we're looking at this from a very cost-effective construction approach. So to build out and create the interior space so that it works with everything really is not economically feasible. It's always more cost-effective to build up on an existing foundation than to create new structures. So this is the main portion of the house onto which we're building. The existing garage is remaining. We're just raising the roof so that we can utilize some of the attic space. It's still attic, but it's going to be storage. So this is then the, and we're relocating the entrance. There's a current stoop, and as you can see from the photographs, it's really kind of long and stretched out, and the different shapes of the roof and so forth. So this is an existing stoop here, which we're actually removing and changing the entrance to the central portion. So this is the main area. This is really more or less a facade. As Linda was explaining, we're adding a second floor here. We're filling in this gap, so it's the facade is one long plane. And then we're filling in this space at the back with a single-story addition. It's just a double-height space, but it's not over the 20 feet, so it can't be included as second floor area. It's just an open cathedral ceiling. So this is then, oops, fit before I was showing. There we go. All right. So this is just the raised roof line, again, on the site. So we've raised this roof. This is the second floor addition. This is entry open to two floors so that the stairway goes up in here. And then this area right here is just a walkway across to get access. Right now they can't gain access to the storage space that's above the garage. And this is a little covered deck. It doesn't project any further, although, you know, against my better wishes, I wanted to come out further. However, I was told that it'd be best just to stay in line with the 34 feet and not try to ask for more, although being an architect, I would have. However, so that's it. I mean, it's pretty simple. It's just the second floor addition on top of the existing footprint. And there is also a little pool house back here I didn't build. But it's not, it doesn't need a variance. It's within all the setbacks and so forth, and the pool is remaining where it is.
Thank you. I should have mentioned that when I first stood up that this is much less. It's 1,000 square feet less than the maximum gross floor area would be. So it's well under the gross floor area limits, and it meets all the coverage requirements also.
What about the 50%?
Okay, she's made an argument that it doesn't apply. We'll have to consider that. If it does apply, I do recall on a couple of occasions where, with special circumstances, that we allowed a second-story addition on a one-story house, even though obviously that normally doubles the area. So we have recognized that one-story houses, can present a different circumstance for the 50% rule than other cases. So overall, I don't have a problem with the application, if that's what you're asking me. I assume that
Well, they're not changing the 34 feet, that's staying the same.
No. I assume that the applicant's attorney would not really care. If the board granted this application, you wouldn't really care which way it did it, by interpretation or by variance.
No.
What you want is the end result.
Correct.
So we'll have to, if we're going to allow it, we'll have to figure out what's the best way of getting there without setting a precedent. But I don't have a problem with it.
Any questions from the board?
No.
Anybody out in the public wish to be heard of this application? So then we'll have to hold it open, I assume, right?
We can close it for
You
decision.
want to close it for decision, okay.
I move we close this application for decision.
I second.
Thank you very
All in
much.
favor?
Aye. Moving along.
Last but not least,
Light. Everybody's here. Huh?
we'll just say yes to this one.
At least I think it is.
Looks like it to me.
On the application of case number 2873, Westerly 2 LLC, 251 Captain's Neck Lane.
Edward Armis, I'm representing the applicant. The project is a small addition onto an existing residence. It's a corner lot on the corner of Captain's Neck and Ox Pasture Road. It's excuse me. It's part of an old estate, so the building itself that the addition's going on was the former carriage house and caretaker residence. And because of the fact it was an estate at large at one time, it was a large piece of property. It was subdivided over the years. And so the house itself is situated very close or to the south end of the property line. So it's sort of at a disadvantage there. So we're looking for to get relief. We're looking to fill in and essentially make an entry into the inside corner of the existing residence. One part is two-story, and the other is the old barn, the garage part of the house. Right now, on Captain's Neck, that is the closest part, the closest road to the residence. Right now, The existing structure is 27.8 feet from the property line on Captain's Neck. The proposed addition would be 38.7 off the property line on Captain's Neck. Of the room, 2 of the walls would be the existing structure. The existing roof, which is single-story, low slope, would be extended over the proposed addition. So from the south elevation, there would be no noticeable difference or addition noticed in that elevation or profile. And there is an existing hedge, a privet hedge along Captain's Neck that is to stay, which is approximately 10 feet tall, provides screening. That's in addition to the survey. We have floor plans, and then elevations consisted of existing photos and then renderings of the addition on the photo showing the proposed work. And right now there is an existing deck approximately 8 to 9 inches above grade. The footprint of the addition would be the size of that deck that's existing now. And that's
In other words, you already had the deck there, you just come and close that to be a mudroom.
Correct. The way they moved around the kitchen, so now the door that's present in the photos enters into the dining room. So they want to go into the mudroom, enter through the existing south wall, or the north wall, to the one-story section, and come into a little mudroom and into the kitchen. So it's more of a typical entrance into the rear entrance into a house.
Any questions? No. Any questions?
No questions?
Anyone out in the public wish to be heard? Please come up.
To the board, thank you for staying so long and listening. I have just one quick question, and that is really if I could just see what those elevations look like.
That's the existing photos.
So it's going to be here?
Correct. This is looking from the north, looking south,
Mhm.
and this would be from the hedge, looking
So
west
from
at that.
Captain's Neck, you would see it?
From Captain's Neck, yes. Ox pasture is so far away that you really don't get a perspective. So this is the inside the yard, not looking through the hedges or anything along Captain's Neck.
Okay, but there are hedges that protect the area?
Yes, along Captain's Neck on the property line, there's
Okay.
hedges, and they'll remain.
Okay.
Okay.
I wish you good luck.
Thank you.
I'm good. Applicant requests a front yard variance to 38.7 feet in order to permit a proposed one-story mudroom addition to the existing house, period. The existing house has a front yard setback of 27.8 feet, and thus the proposed addition will be approximately 10 feet further from the street than the existing house. Furthermore, the proposed addition will be constructed over the footprint of an existing entry deck, period. Upon considering and balancing all relevant factors, we find that the requested variance is warranted, and we grant the requested variance.
I move we accept this decision as proposed.
All second?
All in favor?
Aye.
Good night.
Oh. This meeting of the Southampton Village Zoning Board of Appeals is adjourned.